is John Bell and I'm chairing this session. It's my very great pleasure to welcome Professor Tamara Hervey, who's known in the field of EU law and health law for many years and has been working particularly on EU health law, which is what she's going to be talking about. I was reminiscing a bit beforehand that I'm well aware of the problems of this area, having in my very younger days needed to have recourse to a dentist in Germany just as we'd entered the European Union. So it's a topic of very practical interest, and the presentation we're going to get is actually very much rooted in practice. And so I think this will be a very, very interesting aspect because it's part of the area of Brexit that isn't really talked about enough, and certainly that has been worrying a very large number of people, particularly those who are retired and living in Spain, and who are dreading the thought of having to come back. So Tamara is going to talk for about 20 minutes, and hopefully we will then have an opportunity for conversation and discussion. So Tamara.
Thank you very much, and thank you for the invitation. It's lovely to be here. I was thinking what to talk about, and I came up with this. So this is, here we go. I have to start with this slide because I have to start all of my presentations by saying health matters in the Brexit debate. And here is one of the reasons that health matters in the Brexit debate. There's at least some evidence that part of the Leave vote was persuaded by this suggestion that leaving the EU would somehow be good for health. And of course, we know that leaving the EU is going to be really bad for health. And what I'm going to talk about today is one little corner of why and for whom it is bad in the health domain. Just a little slide about the projects, the various projects and funding sources which have fed into the thing that I'm going to talk to you about today. The main project is this ESRC Governance After Brexit project. But I also have to credit my university, which has an undergraduate research scheme, and Darcy Foster was instrumental. She's an undergraduate in my law school. She was instrumental in this particular corner of the project. So, as I've just said, talking about patients' rights post-Brexit is one part of a much larger project talking about health generally post-Brexit and health law post-Brexit. And the aim of this particular aspect of the project is to analyse the unfolding legal landscape as it applies to health. So as we, for instance, get the new immigration legislation in the UK, what does that mean for health professionals? What does that mean for making sure that there are enough nursing staff? That kind of thing. And in order to do this project, I've been interacting with several third sector health entities, including one large and one small health charity. And the work that I'm talking about today is co-produced with a small health charity called Kidney Care UK. And what did we do? Well, we first of all set out to understand what is happening now. And what is happening now is that Kidney Care UK have built up a quite substantial network of knowledge and understanding about how their clients, their patients who need dialysis typically 3 times a week, can visit other EU countries. And they know which clinics work well administratively, and they know which places people can go to. And of course, dialysis patients are just human beings like everybody else, and it's nice for them to be able to have a holiday, but also they can have lots of reasons to want to visit EU countries. Maybe they have family there, maybe they have children studying there. There's all sorts of reasons. A few dialysis patients even hold down jobs, and those might involve travel. So we first worked with Kidney Care UK to understand what is happening, and everything that is happening is based on entitlements in EU law and administrative structures that come with membership of the European Union. So I don't know how many of you have a little blue EHIC card, but the little blue EHIC card actually entitles kidney dialysis patients to receive dialysis free of charge in another EU member state. And in working with Kidney Care UK, we discovered which 5 member states their patients most often go to. So we focused on those 5 member states, and I'll talk about where they are in a minute. And of course, then we had to understand the current legal landscape, which I've just briefly outlined. This is a gloriously techie bit of EU law, which you can absolutely lose yourself in if you want to. There's loads of cases, there's a very complex regulation, but there is also very transparent patient-facing information that's provided by the European Commission. So it's clear what your rights are, you can easily get information about what they are, and it all works. Part of the reason it works is that the European Union supports something called the electronic exchange of social security information. And that allows social security entities, including national health systems, to share information about patients crossing borders, including these dialysis patients that we looked at. And of course, there's the GDPR, which allows data, patient data, which is sensitive data under the GDPR, to be shared across borders. And if you're going to go and have dialysis, you need your data to be shared in both directions, both with the place you're going and the place that you're coming back again. And then what we did in terms of our methods was we wrote a little scenario. So we looked at the real life human beings that Kidney Care UK works with. And instead of actually focusing on one person and their position, which might have been problematic ethically and in terms of the privacy of that person and their dignity, we made a kind of imaginary person as a composite of these people. And we wrote something like a law problem question, effectively, in imagining this imaginary kidney dialysis patient wanting to go to Europe in various post-Brexit scenarios. And we wrote the scenario on that. This is a snapshot of the poster that Darcy made at the end of the project. It's available on our project website. If you Google health governance after Brexit, Tammy Hervey, you'll easily find it. So this is just some data about what's happening now and about how many people we're talking about. And these, of course, are quite vulnerable individuals. This is the other bit of the poster, already out of date because it has the wrong exit day on it. So basically the way that our legal analysis, our technical legal analysis goes is it's bifurcated into 2 sections. There is a deal bit of legal analysis. If we have the withdrawal agreement, what will the position be of these patients? And then there's a no deal analysis. If we don't have the withdrawal agreement, what will the position be of these patients? So just to talk through that in a little bit more detail. So the withdrawal agreement works by continuing the application of EU law during the transition period, which is the period up to the end of December 2020. The UK government insists on calling it the implementation period, so you might have heard it called that. So that's in Article 126 of the withdrawal agreement. And the withdrawal agreement bill, which we have finally seen, it's been a matter of great excitement. I had to write a different paper in the summer about GDPR and biobanking. And one of the sections of that paper needed to be about how the withdrawal agreement would be implemented in UK law, and we didn't have the withdrawal agreement bill. So I ended up writing something like 2,000 words about what the withdrawal agreement bill might do, how it might do it. But now we do have the bill, so we've got some idea of how it's going to work. So clause 1A of that bill, it effectively continues the obligations under the European Communities Act during transition. So that means that the relevant regulation 883/2004, and all the consequent obligations continue during transition, and they're enforceable by EU nationals in the UK. And that becomes important later on when we're thinking about reciprocity, because the enforceability of EU law is one of its unique qualities, which doesn't apply to ordinary bilateral or multilateral relationships between states. The withdrawal agreement covers people subject to the social security legislation of the UK or an EU member state at the end of transition. And I've already had some gloriously technical conversations with experts in EU social security law about what subject to might mean, because we don't know. But for the purposes of our dialysis patients, what matters is that Article 32(1)(c) of the withdrawal agreement says that entitlement to care under the EHIC continues over the period of time, including the end of transition, until the visit to the host member state ends. So, in other words, applying this to our kind of problem question scenario, if somebody was in Spain, for instance, over Christmas and into the new year 2021, they could continue to receive their dialysis during that period of time. But as soon as they come back to the UK again, that's the end of their entitlement under the withdrawal agreement. But Article 32(1) doesn't specify a maximum duration of stay, and it also, I think it should be interpreted as it doesn't matter what the purpose of the stay would be, so it needn't be an economic activity. But again, it's not explicit in the text. Critically, the UK continues in the electronic exchange of social security information system, and that's explicitly put in the withdrawal agreement in Article 34, and the GDPR applies so that data can be shared lawfully from the EU to the UK. So the withdrawal agreement will deal with things up to the end of 2020 and for a little bit longer for dialysis patients who are away right at the end of 2020. What about no deal? So I think, and it'll be interesting to see what the rest of you in the room think, I think no deal now has two different meanings. No deal is not a technically legal word at all, phrase, but I think it now means two things. I think it means either the UK leaves the EU at the end of the period specified by Article 50 without a withdrawal agreement, and that's now looking less likely than it was a few days ago or weeks ago. It kind of comes and goes over time, how likely that meaning of no deal is. Or it means the transition period ends. So at the moment, the transition period, which can be extended, it ends at the end of December 2020, so quite soon, without relevant EU-UK agreements being in place. Now, all of the discussion not all, but most of the discussion in the media is about a trade agreement between the EU and the UK. But actually, EU law doesn't just cover trade agreements. There's lots of other things as well, and those agreements will need to be in place. So I think no deal in its second meaning could also mean kind of partial no deal. So you might have agreements about some things, but not agreements about other things. And that creates a situation of significant complexity. And legal complexity is one of the themes that's emerging from our work, not just my work, everybody's work on Brexit. So under a no-deal situation, there are no reciprocal healthcare agreements EU-UK, and there are no rights in EU law or in a UK-EU agreement to access dialysis. But that doesn't necessarily mean that there will be no entitlements for the patients that we are talking about, because maybe there will be bilateral agreements on healthcare between the UK and individual EU member states. And here, those of you who are EU lawyers will be immediately thinking, yeah, okay, so there's an EU competence question there then. Is that a field that the member states can negotiate individually on, or is it a field that's actually part of EU competence and therefore the member states' competence is excluded? And there was some reports, for instance, of discussions between the UK and Italy about having a bilateral healthcare agreement. And there is the possibility for migrant patients to rely on domestic law in the host member state, because there's nothing to stop any member state giving healthcare to somebody who is on their territory. They wouldn't necessarily be required to do it under EU law or any other type of international law, but they could nonetheless do it. So let's think a little bit more about relying on domestic law in the host state. And as you possibly know, there is Brexit legislation already in place in many member states. And the member states that we looked at, the 5 member states that we looked at, which are on the slide here, have all adopted some form of Brexit legislation, mainly to deal with the no-deal situation, but the Brexit legislation doesn't necessarily require no deal. In some instances, it comes into effect anyway. So we need to then look at the individual domestic law in each individual country. And what you'll see here is that it differs in the different countries. So in France, the answer to the problem question is really easy, because the French Brexit legislation doesn't cover healthcare for visitors. It only covers healthcare for residents. So that's, our kidney patients, their position is clear. They won't be able to rely on any domestic law there. In Ireland, there's the common travel area. We can park that and talk about that separately. If there's anybody in the room who knows about it, I want to talk to you afterwards. But let's focus on Spain as a really good example. So Spain adopted Brexit legislation, which comes into effect if there's a no-deal Brexit. And it gives entitlements to patients like our kidney dialysis patients with 3 provisos. There has to be reciprocation from the UK. So then the question is, right, okay, so what is the UK going to provide for patients coming in the other direction, Spanish patients visiting the UK? And the question is, the changes that the UK will make and has made under the enabling powers of the EU Withdrawal Act, such as to these regulations, are those provisions sufficient to count as reciprocation? The Spanish law also says that there must be no new administrative constraints on the ability for Spanish nationals to access the UK NHS. So query, is the settled status scheme a new administrative constraint to the extent that this is therefore not reciprocated? And certainly I would make the argument that the first version of the settled status scheme, where you had to pay for it, is definitely a new administrative constraint. It's free now, so maybe it's a bit more disputable. Thirdly, the UK has, I think possibly Spain, I think has quite possibly sensibly said, the UK has to issue documentation to visiting patients to say that they are covered by the British NHS. So that's a classic type of Brexit legislation. Italy and Greece, similar examples. Of course, with no deal, there is no access to or use of the electronic exchange of social security information system. So there are big practical issues. And there is also a need to secure lawful data flow. Now, in terms of data flowing from the UK to the EU, that's dealt with by the amended Data Protection Act, because the UK is going to recognise the EU as a safe space to send personal data. But in the other direction, the EU needs to recognise the UK as a safe space to send personal data, and the Johnson Political Declaration under paragraph 9 suggests that during transition, the European Commission will take an adequacy decision to this effect. I'll talk more about that if people are interested. So, bigger thoughts, and then we can open to discussion. This is a tiny corner of the big Brexit mess, but it's a tiny corner that really matters to some people. Not insignificant numbers of people. You saw the numbers on the slide. And it's a really nice little example about how the EU and about how Brexit isn't just about trade, it's about how people have been living their lives. And as I hope I've shown, different forms of Brexit have really different legal effects. It really matters what kind of Brexit we have, what the situation is. And I think one of the things that is important here is that it looks like it's all politics. All of this is politics. There's all this politics going on. What can we as legal scholars do, or law students do, when it's just all politics? And I think my point here is that it's not just all politics. There are legal texts that we can look at. There are things for lawyers to do. And I think it's really important for us to start thinking through, well, how will the new legal landscape, as much as we know what it is, how will it apply? And then, of course, we need to think about the practical effects as well. So the data flow point is really important in lots and lots of cross-border service situations, not just the tiny example I'm talking about here. And of course, being outside of the EU's significant administrative systems and the EU's significant capacity to share information and interact is going to be, be practically problematic. And then I guess the third or fourth big point I would want to make is that no deal doesn't necessarily mean no law. And I think that's another thing that it's important for lawyers to hold on to. But what it does mean is massively increased complexity. So this is one tiny, tiny little microcosmic corner of the post-Brexit landscape just for health. Never mind everything else. And, in order to understand the legal position, you're going to have to be on top of legal texts from 27 member states plus the relevant UK law. That's what it's going to mean. And these provisions are untested. So, of course, that means increased risk because people don't know what the legal provisions mean. Fifth key point, this can all be done. It's doable. And I think that's another thing that actually sometimes some of the narrative about Brexit kind of becomes almost hysterical. It's like, well, we can't possibly do this. It's completely impossible. And then the response comes back, well, what did we do before we were members of the EU? And I don't think that's a very good response because before we were the members of the EU, all sorts of things were different in our lives. But I think it's important to recognise that, for those of us that think Brexit or have shown that Brexit is a really bad idea, nonetheless, it can be done. But it needs resource and it especially needs time. And this is where obviously we need to do a particular plug for Kenneth's Brexit time work, because the temporal effects of this are really important. There are already many new legal texts. There are going to be more legal texts. The meanings of these legal texts are uncertain. That's going to make it really difficult for people to plan. And where there is uncertainty, there is always the potential for increased inequality, because people who are relatively more powerful, relatively more wealthy, can deal more easily with increased uncertainty. So I think that's a really important part of the post-Brexit narrative that we need to start thinking about. Finally, the implications of moving from membership of a system. So we talk about the EU's legal system, and it is chaotic, but it is a system. It's understandable through a systemic approach to a much less structured set of legal relationships. And that will mean that it's very difficult to provide information about the legal position. It's very difficult to disseminate that information. So basically, Kidney Care UK, on the basis of our work, are saying to their patients, do not go to another country unless you can afford your dialysis through private insurance or private money. Because it's too risky to try to rely on the provisions that are there, that we've discovered. So, and it's also really difficult for Kidney Care UK to explain to their patients what the situation will be, their legal position. And it also means that scrutiny of law is going to be difficult. And I think that raises questions about legitimacy of the post-Brexit legal landscape. And, this whole narrative about let's take back control and make things simpler is just fundamentally flawed. Okay, I've talked enough.